Good evening and thanks for joining us. Wishing you all a very happy new year, though belatedly. We'll get started given that these are the different segments which we normally cover every month, but this month we don't have much or rather anything at all in the amendments and ordinances. Moving on to circulars and notifications. PF again comes about with UAN and seeding of Aadhaar and the deadline for the same for the EDLI and ELI. So employment linked insurance scheme also you're required to do the Aadhaar seeding with UAN before 15th of January 2025. All the labor boards have been issuing notices calling upon employers to contribute to the labor welfare fund. So if any of you have not done the contribution to the labor welfare fund, ensure that you do the labor welfare fund because 31st December would have been the last date in most places. ESI again goes on with Aadhaar seeding with their employee number that they have generated. How you could do on bulk Aadhaar seeding and things have been explained in their recent notification. I mean, the Aadhaar can be verified using OTP, biometric, or face authentication as well. So on this aspect, they have issued a circular. The next segment, the quiz segment, the question is in which language should the certified standing order should be displayed? Please do post your answers in the chat box. In Australia, if an employer were to underpay an employee knowingly, they've made it as an offense up to 10 years. And apart from fines which could go on a penalty of in millions. In India also, we have something very similar to this under the Minimum Wages Act, where the penalties could be up to 10 times, and there's also a possibility of prosecution. This is an amendment that they have brought about. The underpay, but however, it should be established that it was done on purpose and with knowledge. There is the Trade Union and Labour Relations Act of 1992 in UK provides for a mechanism where there should be a dialogue between the employer and employee if they were to retrench or redundancy and try to see different aspects. So there's a 90-day time frame, or the time frame depends on the number of employees to be sent out. It ranges from 30 to 90 days. If this consultative process is not carried on, then the compensation that the tribunal can grant is being enhanced by around 25%. They could enhance it further, the compensation that they could if they don't have the consultative process with the unions. This month, given that we are moving into the new year, we are just trying to update you on the case laws of 2024. In this judgment, the Supreme Court dealt with the question as to what issues can be considered by the Labour Court and what can be considered by the tribunal. Normally, if 100 or more workmen are involved, disputes are sent to the tribunal, but it's only on certain issues given in the schedule, like wages, bonus, etc. But where it is less than 100, it has to only go to the Labour Court. So on that aspect, this judgment was rendered by the Supreme Court. There are two judgments of the Supreme Court in 2024 on this aspect. One says that merely having a junior does not make an employee a supervisor or manager. But what is to be required is to see the nature of duty is paramount. So the duty that was cast upon him, that needs to be seen. The other judgment is where a senior sales manager, the Labour Court held that as he didn't have the power to appoint and he would could not dismiss, he could not take disciplinary action, therefore he would not be a workman. The Supreme Court clarified that this is not the only issue. Of course, that in that question, sorry. In that dispute, there was also another question where the employee said his resignation was not out of his free will. And in fact, even while resigning, he had said that. But despite his resignation saying that, the Supreme Court came to the conclusion that the resignation was voluntary and certainly not a coerced resignation, and held that there was no termination, but it was only a case of resignation. Section 29 and Section 34, the prosecution has to be initiated by the government. And on what context the government can initiate prosecution of an employer unless there is a award or settlement and it is being breached. Only then a prosecution can be sanctioned, is the question that was answered by the Supreme Court in this case. So this is more on a civil jurisprudence, service jurisprudence rather than a labor jurisprudence, but they found that suppression of a criminal antecedent. But then the question is, did the employer ask for the criminal antecedent would be a question. So as an employer, when you seek data from your employees or your potential candidates, you would need to seek for the criminal antecedents and background details. And if they fail to divulge and later on it comes to your knowledge that they have a criminal antecedent, it would be possible for you to dismiss them for having withheld information from you as an employer. We all look at plenty of wage disputes that come across, charter of demands, union signing settlements. The touchstone of all this adjudication is the financial capacity of the employer. In this case, where the employer didn't have the capacity, despite that the tribunal went on to grant certain benefits, the Supreme Court said that without the financial capacity, no increase could be granted, because it remanded the matter back to the tribunal, but this is the law that it has laid down and rather reiterated. So unless the employer has the financial capacity, the question of adjudicating a wage dispute would not arise. In our next segment, the Did You Know, we are looking at the codes. There are already queries in the chat box on what is the stage of the codes being implemented. By what is being said by the Ministry of Labour, it doesn't look like the codes are going to come in the first quarter of 2025. It's going to be either 1st April or thereafter. But it looks like 2025 is the year when the codes are going to be notified, but this is the status as on date. This is a case where the employer was prosecuted for an accident under the Factories Act, but a prosecution against the manager was launched under the Indian Penal Code as well. The Bombay High Court struck down, saying that once he has been prosecuted under the Factories Act, the question of prosecuting for the same negligence under the Indian Penal Code would not arise, and struck the criminal complaint against the manager of the factory. Again, this goes into service jurisprudence where employees were working as part-time or casual for a very long time. Following the judgment of Umadevi of the Supreme Court, the CAT and the High Courts rejected the claim for regularization, but ultimately the Supreme Court said because they have been working for a long period of time, they would need to be taken. So this analogy could come in even in labor law when it comes to contract labor being employed for very long periods of time, especially when the contractor changes, but the contract labor doesn't change. The knowledge corner topic for this month is what constitutes a misconduct. Under labor law, misconduct refers to an employee's behavior, but then it needs to be codified. So it is not at the whims and fancies of the employer to conclude as to what is a misconduct. The standing orders, these are what will be construed as a misconduct. is certainly not to the vagaries of the management. This is what Supreme Court said. But it should either come under your standing orders, or if your service, a public sector undertaking within your rules or regulations. But the misconduct should be defined somewhere. And in addition to your standing orders, you may even consider sometimes putting in misconducts in your orders of appointment. So unless a misconduct is mentioned in the certified standing orders, you cannot proceed against an employee. One normal query that comes to us is an employee has been arrested for a criminal case or for some criminal complaint. If you look at your certified standing orders, mere arrest of an employee for an alleged criminal conduct is not a misconduct. Therefore, you cannot proceed against an employee merely because he's been arrested by the police. You would need him to get convicted, and only thereafter you'll be able to dismiss him from your service. So, a lot of queries on misbehavior and what could be. So, all this would be within the scope of a misconduct. You would need to refer back to your appointment order and your standing orders or any other rules. So the next question that has normally cropped up in misconduct is, any misconduct should be related to your employment. But let's assume it is related to an employment, but it happens outside the factory. So these questions, that question was also considered by the Supreme Court, and it came to the conclusion that even if it is an incident outside the work area, the factory, still if it is connected with the employment, it will amount to a misconduct, is the conclusion by the Supreme Court. Moving into our POSH segment, this is a case in where in Kerala the employee was dismissed for dereliction of duty. She challenges the termination. The district collector receives an anonymous complaint based on which the local complaints committee begins proceedings. And ultimately, the LCC comes to the conclusion that the respondent is guilty, would need to apologize and as well pay compensation. But then there was no oral written there was no written complaint at any point of time. There was only an anonymous complaint, and then of course, the victim was examined by the LC, but they said because there is no written complaint, which is a mandate of Section 9, the complaint or the recommendations of the LCC itself is bad. So therefore, at any point of time, you get to hear about a POSH complaint, you need to ensure that there is a written complaint by the victim. The answer for our quiz question this time is that it should be in English and the language known to the majority of workmen of your factory or industrial establishment. This is the complaint chart. We would be sharing it with you when we share the PPT. Things to be done in January 2025. Wishing you all a great 2025. Hope to connect with you again on 3rd February 2025. Thank you. Thanks for joining and listening.